While we all start to see our parents begin a slow decline, for some it happens earlier than others, for some it happens faster than others. But typically there's a triggering event that requires a shift in care and oversight. It's either a physical or mental failing by the elderly parent. Perhaps it's due to a fall that creates some cascading physical issues with the parent, or perhaps it's you learn that your parent took a phone call from a stranger and gave out their social security number. These type of situations can indicate the need for the child or the loved one to step in. It's really important to pay attention to these signs that, may be subtle, but are indicators that, that some more attention needs to be given to the parent. And then it's also, of course, important to watch for the pace at which the parent's frailty, either mentally or physically, is developing. And of course, there's all sorts of emotions around this phase in life. Lauren and I are really going to focus on the legal and financial component of this life event. So the dilemma, as the child who is beginning to shift to this caregiver role, the questions you're faced with are, do they need help? If so, what kind of help is it? What's the best way to approach this topic with them? Of course, this is, usually very emotional and a highly sensitive issue for the parent to sort of realize their own diminishing capacity. So, and it's not always a conversation or a dynamic of the relationship that is exists up until that point. And then who is responsible and what can they afford? So again, while the first three questions are certainly, really important and require a lot of energy and soul searching, today we're going to really focus on the last two questions. Who's responsible for making the decisions on behalf of the elderly adult, and what can they afford? So Lauren, can you share with us the legal tools that are available to the caregiver child?
Sure. Again, welcome everyone. Thanks for joining us today. So we are really focusing right now on answering the first of our two questions, which is who's responsible? And there's some legal tools that are going to help us make that determination. It's so critical this phase to see whether or not we have powers of attorney in place. There's two types of powers of attorney. There's a healthcare power of attorney and a financial power of attorney or property power of attorney. And at this junction, we are looking for both. It is not uncommon for a parent or a family member to have obtained a healthcare power of attorney at some point, whether it's through a hospital stay or through a doctor's office or even at a senior center. There's a lot of opportunities to get a healthcare power of attorney in place. There's fewer opportunities to get a financial power of attorney in place unless you're going forward and trying to seek that sort of a document. With both powers of attorney, they allow someone to be an agent or appointed by the principal making the document to make either healthcare or financial choices on behalf of that principal when they can no longer make those choices on their own. Both documents are incredibly important when it comes to this period of time because they allow someone else to be responsible, right? Whether it's healthcare decisions or those financial decisions. If we don't have anyone appointed to be responsible, then we might have to go through the guardianship process if our parent has reached a point in their diminished capacity that they can no longer make decisions. Meaning, a doctor has said, based on this person's diagnosis or prognosis or current circumstances, they are unable to make their own healthcare or financial choices. If that's the case, then we have to go through the court to get a guardian appointed, which is a legal proceeding where we go through essentially a hearing to get a guardian appointed to make those types of choices on behalf of a disabled person. The preferred method for figuring out who's responsible is to do it through the power of attorney mechanism. this is a much less of a hassle. It costs less money. There's not as many people involved. And this way, the principal is the one who is appointing that agent. They are making that decision. So we know exactly who the agent's going to be, and everyone is on board with that decision. Through guardianship, it's usually a family member who steps in to be the guardian, but sometimes it isn't. And it's also possible that the family member you may want to be the guardian is not the one who's going to end up being chosen or decide to act. So to kind of eliminate that guesswork, powers of attorney are preferred. Not all powers of attorney are created equal, though. So when it comes specifically to the financial power of attorney, there are different powers that we can grant our agent within that document. It is incredibly important that when we are reaching the circumstance such as this, where we have this crisis, we have a need, we look at that power of attorney to determine, A, is it effective immediately, or do I need a doctor's letter to have this document be effective? And then also, does this document give me all the powers I'm going to need to successfully navigate this situation? Does it give me the ability to make gifts? Does it give me the ability to hire a caregiver and sign on behalf of the principal? Does it give me the ability to engage in long-term care planning and apply for Medicaid? What does it allow me to do and what doesn't it? So it's incredibly important that we take a look at these documents, figure out when they're effective, figure out if we have them, and what do they say. So they're tools that we can use if we can get our hands on them.
And I'll just chime in with that, I encourage my clients, to take the power of attorney, the financial power of attorney very seriously. And it should not be just a cookie cutter power of attorney. It should really be a well understood, so that everybody is clear in what sort of authority you as the designated power of attorney has, so that if you're in a crisis situation, you're clear on what you can and cannot do, and it's all thought through.
Exactly.
So if it's been determined that the person, or perhaps it's a couple, can afford to pay for either in-home care or an assisted living facility of their choosing, as the financial advisor, our approach to caring for this kind of client begins to shift. Our primary focus turns to ensuring that we can help facilitate the cash flow required to fund the care that's needed for the client. We will work with the family member, or perhaps it's a third party, such as a personal finance manager, a bank, or a bookkeeper, who's responsible for making sure all the bills get paid, that insurance forms are submitted, that proper care is hired and compensated as needed for the parent. We'll work with the family accountant or a state attorney to deal with the issues that arise through this transition. From a portfolio management or investment planning standpoint, the investment strategy will shift to more of an income generator and capital preservation than on growth. And we might maintain a small growth component within the portfolio to ensure that the client does not outlive their assets. But certainly the objective becomes more about capital preservation and liquidity. We'll generally hold from 9 to 12 months of needed cash to cover the parent's expected expenses. And again, first and foremost, the priority becomes about ensuring that we're able to provide the cash flow needed to cover the parent's expenses. We ensure that RMDs get processed and work with the family and their accountant to optimize the client's tax situation. People don't realize that when you get to this stage in life with the significant medical related expenses, if there's no long-term care insurance, these medical expenses are tax deductible. But of course, the client is no longer generating earned income. So if the portfolio isn't generating enough taxable income to offset the medical expense tax benefit, we'll look to increase IRA distributions to allow the family to take full advantage of those tax benefits. We will also provide the family on a quarterly or semi-annual basis with a projection of the client's financial surplus or deficit based on their current drawdown levels. And again, this allows the family to make well-informed decisions for the parent if and when their health deteriorates or the level of care required changes. Now I'll hand it off to Lauren to discuss the situations where there is limited or no ability to pay.
Thank you, Jen. So in a situation, unlike what Jen just described, where there is money to pay for these sorts of long-term care expenses, which can be extremely costly and very devastating to anyone's financial plan, when people have some ability to pay or a period of time in which they feel that they can self-fund their long-term care, there's a few different options that an elder law attorney is going to recommend. The biggest goal with people who have limited ability to pay is trying to preserve those assets that we have to make them work for us as long as possible. And usually that involves coupling those assets with a government benefit. So there's two different types that I wanted to talk about today. But before I even get into the idea of government benefits and assets, the idea of asset protection planning is one that is more and more people are getting used to it, and they're hearing about it, and they're interested in the idea of asset protection planning. And there's always an opportunity to preserve assets for individuals who have a limited ability to pay. That is the name of the game. That's what we're trying to do. The reason why we're trying to preserve those assets could be because it's a situation where we have a spouse and that spouse is ill, and we still have a community spouse or a well spouse who's living in the house and needs funds for their own care when they become ill. It could be a situation where there's a disabled child and we're trying to preserve assets for those children or child. It also could be a situation where we understand the limits of what the government benefits are able to pay for, and we want to use some of these funds in a protected way to make life nicer. So there's always a reason to do it. Question is whether or not are we able to. And the two main government benefits that I want to discuss are Medicaid and the VA. So Medicaid is a government benefit that pays for room, board, and medical expenses for an individual in a nursing home or supportive living facility. So a nursing home is the highest level of care, and a supportive living facility is the functional equivalent to assisted living. So it's kind of like a medium level of care. Supportive living is different than assisted living in the sense that supportive living accepts Medicaid and assisted living does not, which is important to know. When we are looking at a supportive living community or a nursing home, there's an opportunity there to preserve some of the assets by using asset protection planning strategies. There's a variety of strategies that we might be able to use depending on the circumstances. Some of them involve making gifts to certain types of trusts that mean that those assets are protected from a government spend down, right? So we don't have to spend that money down on care. Some of them could be transferring a house to a caregiver child if that child has lived with the disabled person for at least 2 years. There's other strategies that could be involved if there's a disabled child, so we can transfer funds to a disabled child. So there's a few different strategies that we could engage in when it comes to asset protection planning, but they all involve taking someone's money and preserving it so that we don't have to spend it down, all of it, on care. Again, the reasons for being that can vary based on the circumstances. But we couple Medicaid benefits along with these strategies so that we can take advantage of the government benefits while preserving some of these funds. So that's one way to do it. Another option for people with limited ability to pay would be to take advantage of the VA. The VA has a pension benefit called the Aid in Attendance Pension Benefit, where they give you tax-free money on a monthly basis, if you qualify, to pay for long-term care expenses. That could be for home health caregivers, that could be for assisted living, it could be in a nursing home. You can actually even pay your child to give you care with the appropriate legal documents in place. So there's a lot of flexibility there, and it is a cash benefit that the VA provides to offset some of these costs. The difference really between Medicaid and the VA is the amount of the benefit. So Medicaid pays for the full freight, room board, all of it when it comes to supportive living and nursing homes, whereas the VA benefit is a set dollar amount regardless of how much your care costs. For people with a limited ability to pay, that additional monthly income from the VA may be enough to keep them in their home for longer or keep them in assisted living for longer. So it's an option to try to make that money work for us a little bit longer than maybe it otherwise would have. For both Medicaid and VA, there are asset and income requirements, which have to be met in order to qualify for the benefits. There's definitely planning strategies that can be taken advantage of to have someone qualify sooner while still being able to preserve funds. And that is also an option too for both of these. The next slide has to do with no ability to pay. And this occurs usually when an individual has either gone through their resources, so they have stayed at home and paid privately for caregivers or lived in assisted living, or they just don't have the resources to pay for care. If that's the case, there's two programs that fall under the Medicaid umbrella that they could potentially take advantage of. Depending on the need for care, so if it's a situation where somebody could use up to 20 hours a week of a caregiver coming into the home to provide them with assistance with their activities of daily living, there's a community care program under the Medicaid umbrella that an individual can take advantage of to have that care provided to them. You have to meet certain income requirements, and the maximum that is available in terms of hourly caregiving time is about 20 hours. So this would not be applicable for people who need 24-hour care or who need more extensive care. If you don't have the resources to pay for that, then this community care program isn't going to work. But it's a great option for somebody who needs just a bit of care. In addition to the community care program, there's the long-term care program for Medicaid, which, as I mentioned, pays for room, board, and medical expenses in a nursing home or supportive living facility. And it pays all expenses associated with that person's stay, pays for incontinence supplies, prescriptions, you name it. It's all covered under the Medicaid umbrella. So it's a very robust benefit. As a result, the requirements to be able to receive this benefit are equally robust. There's a 5-year look back where we are looking at your financial records for a full 5-year period, all accounts, whether they're opened or closed. And it's a very extensive review process that can take, previously before recent changes to policy manual provisions, it could take a year or more to get through that process with the Department of Human Services. They are looking for any transfers for less than fair market value or gifts. And if there are transfers, then that could result in a Medicaid penalty being imposed upon you. The way asset protection strategies work is that we anticipate such a penalty and we take steps using your resources to plan for that while still preserving funds. If you don't have any funds, then asset protection planning is not going to be the way to go, and we would just be looking to get you situated with a Medicaid bed in an appropriate nursing home and making sure that you qualify for Medicaid. So making sure all the appropriate documents are submitted and that the application is approved, which, as I said, can be a lengthy and daunting process. Not all nursing homes accept people straight on Medicaid. A lot of them want private pay before you end up applying for Medicaid. And that situation can vary, like the amount of that private pay period can vary based on each individual facility. So it's important to keep that in mind too. If someone is planning to stay at home and run down all of their funds, there's usually what I tell individuals is you can run down most of them, but don't run down all of them. Because if you run down all of them, then we will be in a situation where it's going to be very, very difficult to find a nursing home that is going to accept you, what we call Medicaid pending. You have more flexibility and more options if there's some private pay with which to give to these nursing homes before applying for Medicaid.
For those that are self-funded, the question arises, what kind of timeline should I expect once we realize we have to begin shifting responsibilities? And obviously in a self-funded situation, you're going to have a lot more flexibility on timing. You don't have the issues that that Lauren just addressed. But I would say, again, the most important element that is time sensitive, because you just don't know when the shift's going to occur, is getting that POA with the appropriate language in place well in advance of any physical or mental deterioration. It's much better if it can just be a conversation between the child and the parent. And it sort of allows that process and that shift in the relationship to occur in hopefully a non-stressful, non-emotional situation. It certainly becomes a lot more challenging if they've already declined and are now unwilling or unable to give you, as the caregiver, the authority you need to make these decisions that are in their best interests. And as Lauren discussed, it can get complicated and take a lot longer. As an example, we had a situation where a client was dealing with a bit of a crisis with her parents, and she thought she had the right POAs in place, and it turns out it did not have. It was a more stringent language that required a doctor to sign off that the parent was no longer able to care for themselves. She was out of state, and it just made the situation much more stressful than it needed to be. Had she had the right language in place, she could have just sort of kind of swooped in and taken care of things. So, once, again, that is definitely the most time sensitive. And then from a planning standpoint, we're able to, quickly gather information based on the resources and needs of the parent and provide the family with an analysis needed so they can make an informed decision as to what, whether it's a in-home care or a facility, a preferred facility. We can provide that analysis to help the family understand what either the parent can afford or what they might need to consider supplementing. And again, this all feeds into, sort of how the financial management and how the investment portfolio needs to shift to handle the new expense level.
For anyone who is planning for a long-term care event, it would be ideal if we started looking at these things 5 years or more in advance. The truth is, we don't have crystal balls, and I don't know what I'm going to be doing in 5 years. I would wager none of you do either. And it's very difficult to wrap our minds around the idea of ourselves, our families, our loved ones deteriorating in 5 years to such an extent that we have this long-term care event or crisis. That's a hard thing to plan for. And so it's not often that I run into individuals who are coming to me with enough time in advance to do what we would call advanced Medicaid planning. So we would be able to preserve more assets in that situation because we are getting out ahead of the crisis. I would say that most of the time, individuals with a chronic illness or someone who has been diagnosed with a disease that is going to get progressively worse over time to where they know they're going to need care. Those are the individuals I see who are doing the more than 5 years in advance planning because they understand the need for care and they want to get out in front of it. Most of the time, the situation occurs where there's a crisis, what we call crisis planning, which occurs within the 5-year look back period or within the 5 years that Medicaid is looking back to see what we've done with our funds. And it's very common and there's nothing wrong with it. And that's something that I can't stress enough. Many people feel like because they did not make that 5-year timeline, because they didn't plan in advance, there's no planning options or strategies available to them. And that's simply not true. There's plenty of strategies available to you. I can't save as much money potentially as what we could have saved if we were planning more than 5 years in advance. But that doesn't mean we have to throw in the towel. It just means we have to look at it a little bit differently. So ideally, we'd want to be planning for more than 5 years, but if it's less, that still gives us the opportunity to do what's called crisis Medicaid planning. and plan with at least a few months in advance notice. A few days is hard for me, but a few months is I can do that. And we can get a plan situated to where we can get the Medicaid application, situated, a VA application. We can get things moved around. It's an emotional time for people. If a loved one is experiencing some sort of a crisis, they're hospitalized, they need rehab, they found out they can't go home. If there's an emotional component to it that's already difficult, trying to work under very strict, hard deadlines and move very quickly is also difficult. So give yourself some grace in that and understand and know that there's the more time we can get out in front of it makes your life easier. But even if we can't, there's always options. When someone comes to me and they're in the midst of a long-term care crisis, they are in a nursing home, they're in a supportive living facility, and they already are spending money, or they're about to, they're getting the bills. I can still save between 50 and 60% of their assets over and above what Medicaid allows someone to keep. So there's absolutely a reason to do it, and there's time to do it. And so there's really no time where it's too late to save money. Sometimes the communities kind of sway you to a certain extent, right? Depends on who you're listening to. But and that's why it's so important to have independent advisors, like financial advisors and attorneys, who are in your corner giving you unbiased advice. We don't have any skin in the financial game. We're just trying to preserve your assets for you. And so it's never too late to save money is the end result.
And, long-term care insurance is kind of a tricky topic because it is very expensive insurance. And unlike policies that were issued, 20 years ago or maybe 25 years ago when long-term care insurance first came out, they are much less generous policies now and are very expensive. But some people feel strongly, again, if they've been through a tough experience with their parents, and they are just, pretty adamant about not wanting to risk putting their children through that. So then the question is finding the right balance, because obviously, you really don't want to get long-term care insurance in your 30s when you're more than likely not going to be needing that insurance for 40 plus years. But of course, that's when your premiums would be the lowest. And then, if you wait until you're in your mid to late 60s, then the premiums are going to be so costly that it doesn't make sense either. So I think for those that really do want to have that security, figuring it out at some point in your 50s is usually kind of the right balance, where premiums are reasonable, it's not that far down the horizon that you would potentially need to use them. Also keeping in mind that, the insurance companies can really jack up premium. So you think, you're paying a reasonable premium in your 50s, and then you get into your mid to late 60s, and all of a sudden it gets doubled. So anything's possible with long-term care insurance. So it is definitely a tricky decision to make. We try to come up with different ways of sort of subsidizing that. For example, we encourage clients, if they're able to, fully fund your HSA account, and then if you don't have to, don't pull your assets, don't reimburse yourself for medical expenses. Allow your HSA accounts to just grow, get them invested, fully fund them, so that at that point in time where you might need some to be funding some long-term care, it's not going to fully fund it, but it could give you a nice base to use towards long-term care.
When you're looking at that power of attorney, if you especially put it together at a time when maybe your kids were young, or it was 10 or 15 years ago and circumstances were different, And now we're reaching a point where maybe we're retired and we're looking at long-term care events differently. So making sure that that power of attorney includes powers that you might not have thought of or needed 10 or 15 years ago when your kids were younger and your concerns were different is going to be really important. But an estate planning attorney should be able to help you with that.
Okay, that's great. Thank you. And I think we have another one here. If you care for an elderly parent and have a healthcare POA that indicates the parent retains decision-making until they are no longer able to do so, what are the hurdles involved to transition from the parent making their own decisions to the child assuming the decision-making?
Also a good question. So depending on when that power of attorney was enacted is going to sort of dictate the language that's in it. But if it was relatively recent, within the past, let's say 5 or 6 years, usually you're going to have to get a doctor's letter that says this person lacks the ability to make healthcare choices or healthcare decisions on their own, and then the power of attorney would be effective. The difficulty with that event is that you have to keep that doctor's letter with the power of attorney in order to really use it. Otherwise, the choice that you made in that form or the choice your parent made in the form is still going to reflect the idea that you don't have any authority to make decisions. So the doctor's letter is going to need to be on file with your doctors and hospitals, anyone who you potentially need to make a healthcare decision with. If mom still retains decision-making capacity, sometimes it's easier to just update the power of attorney to maybe give you a different option, depending on the circumstances.
So Lauren, taking that one step further, so say mom is resistant, you have concerns, is it then that the child then has to go the guardianship route if it's gotten to that point?
That's a good question, and that depends. So guardianship is reserved for individuals who lack capacity. So a doctor would have to certify and be prepared to testify at a hearing that this individual lacks decision-making capacity. That means that the doctor's got to be pretty certain that the individual does not have the ability to make decisions. If it's someone who has the ability to make decisions but is making bad ones, or ones that we consider to be bad based on our own opinions, that is not guardianship worthy. People have the ability to make bad decisions. They do it all the time. And that doesn't necessarily mean they don't have capacity. It just means they're making bad choices. And there's a huge difference there. And it's very difficult when we see self-neglect or people not making good choices with their money or people answering the phone to people that I shouldn't be. When they have capacity, they have the ability to do these things. So it's not as easy of a situation as, I don't like your choices, I'm going to drag you into guardianship court and take over. We as a society do not like stripping people of their legal rights unless we absolutely have to. So keep that in mind. So there's a few legal standards, but usually the guardian is a family member. It could be a spouse, it could be a child. And the judge, who can't necessarily interview every single disabled person and find out what that individual wants, is going to appoint what's called the guardian ad litem, who's an attorney who would go out and meet with the disabled person and talk to the family members to see what the situation is. It could be a situation where mom absolutely hates her son and she does not want him to be guardian, and then it becomes an issue as to, well, why not? Maybe there's a better family member who's suited for this. And then they kind of do some investigating to see whether or not that petition being brought by the potential guardian should be granted. For the most part, it's pretty rare that there's a circumstance where someone is petitioning who really is not the best suited. Again, that investigative process usually susses things out pretty well. And it just, the guardian ad litem, they do a good job of trying to figure out whether or not this is the right fit. The other piece of this is there's constant oversight pretty much by the court. Maybe not constant, but there's continual oversight by the court. So people who are in it for, nefarious reasons are not going to get very far, because the judge is going to be overseeing the financials and the decision-making of this guardian. And so there's really very little motivation for someone to get involved with all this court proceeding if they're not in it for the right reasons.
If a child is responsible for a parent's care, is it recommended that the parent also be included in the financial planning process surrounding their funds and care? So Jen, that might be for you.
Yeah, in answer to your question, absolutely. Assuming the parent is sort of has the capacity and frame of mind to sort of, understand what's going on. So, but certainly, if they do and they are capable, then bringing them into the conversation, I think, eliminates a lot of, uncertainty and fear. That's what tends to happen. Am I going to run out of money? Are we going to be able to afford the care that, that we're taking on? So to the extent that we can show the parent that they, that they're okay, that they have sufficient assets, I think is helpful to all parties. So that's not always the case. Sometimes it just gets to a point where they just don't have like the mental capacity to really even understand what's going on. But certainly if they do, it's a great sort of element to the whole planning process. There's a lot of resources out there that can help through the process. Again, whether it's a personal finance manager, a third-party care facility consultant, there to, people coming in and helping you move and pack up and get your loved one into a facility. There's tons and tons of resources out there, and I know Lauren and I know several people that are wonderful and very experienced. So to the extent that you need that kind of help, feel free to reach out to either of us, and we're happy to answer questions around that.